I'm Vinny Politan. Great to have you with us tonight here on Closing Arguments as we focus on the closing arguments from Kenosha, Wisconsin today. This was unreal, what we saw today, because it was so indicative of what this case was like. I mean, there's eyewitnesses and videotapes of almost everything that happened, or video recordings of everything that happened that night. But these two sides could not see things more differently. It's unreal. The video was there. The facts are somewhat in dispute. Some of the facts, things that, what are you exactly looking at in that video? The sides just can't agree to it. And today it was time for closing arguments. And I think we've kind of seen this throughout the trial, that the attorneys on these two sides don't really get along. I couldn't see them ever speaking to each other anywhere other than perhaps inside a courtroom during a sidebar, because they just seem to be so different in their approach, in their presentation, how they speak, how they see the world, even how they dress. And it's amazing. And as I watched the closing arguments today, I'm wondering which side is going to be able to have that connection and that bond with the jury, because that's important. That's really important, especially in a case like this where the law is there's a lot of subtlety to the law, and trying to figure out the burden and what the evidence means and putting it all together. To me, this is a case where the closing arguments can make a huge difference, an incredible difference for this jury. Sometimes you can't. Sometimes, one side is arguing the facts of the case that just don't line up with the evidence. But here, both sides are pointing at the same exact evidence and seeing slightly different things, but then their interpretation of the law much different. And who is the jury going to trust? Obviously, they look to the judge, but one side or the other can create that difference, that tipping point that will bring the jury together on one side or the other. And I'm not sure. I haven't seen this jury. I haven't eyeballed them. And to me, it's a lot about who the prosecutor is, who the defense is, and who is creating that connection with the jury. Today, all about the closing arguments. Let me show you some of the big moments.
Although the defendant claimed to be protecting a business that he wasn't familiar with, the actual killings in this case had nothing to do with that. And he also spent the entire evening lying about the fact that he was an EMT. Here's the defendant running in between those parked cars, slowing down, and you can see just how close, or rather how far away, Mr. Rosenbaum was when the defendant shot him. We'll never know what Joseph Rosenbaum was thinking because the defendant killed him. So we're just guessing. But let's assume for a minute, yeah, Joseph Rosenbaum is chasing after the defendant because he wants to do some physical harm to him. He's an unarmed man. This is a bar fight. This is a fist fight. This is a fight that maybe many of you have been involved in. Two people, hand to hand, we're throwing punches, we're pushing, we're shoving, we're whatever. But what you don't do is you don't bring a gun to a fist fight. That's why he's got to come up with this cockamamie theory that Joseph Rosenbaum was not only going to take the gun, but take it and then turn it on the defendant. And the defendant actually told you that he thought Joseph Rosenbaum was going to take that gun and not only kill him, but kill other people, which is really ironic considering the defendant is the one who killed people in this case, and the only one. But putting that aside, they have to convince you that Joseph Rosenbaum was going to take that gun and use it on the defendant because they know you can't claim self-defense against an unarmed man like this. You lose the right to self-defense when you're the one who brought the gun, when you're the one creating the danger, when you're the one provoking other people. In just a few seconds, the defendant kills one person, attempts to kill two more, and blows off Gage Grosskreuz's arm. It's that fast. And these folks that are coming at him, the jump kick man, Anthony Huber, aren't armed. They're not a credible, imminent threat to his life. They are trying to stop an active shooter.
This case is not a game. It is my client's life. We don't play fast and loose with the facts, pretending that Mr. Rosenbaum was Citizen A #1 guy. When my client shot Joseph Rosenbaum, he feared for his life. He feared because of the prior threats, the prior statements, and the violent acts that had been witnessed by my client. What you see throughout event number 2, and this is the beginning of it, is individuals working in a mob. They don't know what happened at Car Source 3, event number 1. But somebody said, hey, he shot somebody. Doesn't know that he was being chased by a crazy person. Ladies and gentlemen, it's a tough choice, but the evidence only leads to one conclusion. That is that Kyle Rittenhouse's conduct on August 25th was privileged based upon the actions of Mr. Rosenbaum and others. There are no winners in this case, but putting Kyle Rittenhouse down for something he was privileged to do will serve no legitimate purpose. I ask you to do this, do justice here under the law of the state of Wisconsin.
The way they dress, the word choice, the way they speak, the tone with which they speak, the way they look. I mean, it's just completely different. I couldn't see these two guys hanging out together anywhere. Let me get some more information. Court TV legal correspondent Chanley Painter joining us live from Kenosha, Wisconsin tonight. Chanley, great to see you. That's my take on these two guys, that they are just from different worlds. And it's not just prosecutor defense, it's just the way they dress, the way they talk, word choice, tone, everything about them just seems so different. One has a pocket square, the other one's got a bunch of pens in his pocket. And there's nothing wrong with either one. I'm just saying they're totally different. Does either one of these resemble the jurors more than the other? Because I haven't seen these jurors.
Yeah, I hear opposites clashing inside the courthouse the whole time. And it's interesting you notice that. That's an interesting question. Now, these jurors skew a bit older. They come to court casual, business casual type of dress. But I have to tell you, Thomas Binger, he comes with a new tie, the pocket square, a new button, different button on his suit every day, and most of the time buttoned up. Mark Richards, a different story. Even how they sit at counsel table is completely different, Vinny. We have Mark Richards, who almost practically has his legs put up on the desk, let's just be honest, most of the time. But then Thomas Binger is sitting up straight. He is leaned forward. He's taking notes. He's in tune. Completely different personalities inside this courtroom, and it came across today in those closing arguments for sure. All
right, so describe the picture inside the courtroom and any sort of jury change from one attorney to the next, in anything that they're doing, anything that you picked up on, anything you noticed, and comparing these two presentations today, which were so important.
Oh, so important. Game changers today, Vinny. And the prosecutor, Thomas Binger, he seemed to captivate this jury as he told a methodical story. And his delivery was purposeful. He was slow, matter-of-fact delivery, going through video and still frame step by step. And through before the lunch recess and even after, the jurors were leaning in. They were looking at the video. They seemed to be with him through much of his closing arguments. And at the afternoon, there's a lull after lunch most of the time in a courtroom, Vinny. That was apparent sometimes through some of the jurors, but when a new speaker gets up and speaks, like Mark Richards, who doesn't need a microphone inside of a courtroom because his voice seems to boom throughout this giant courtroom in a different style, it perked up these jurors again. I didn't notice anyone checking out during the defense closing argument. They were following along. It wasn't until the rebuttal closed, which it had been a long day, hours of closing arguments, that these jurors were exhausted. You could tell on their faces, their body language, how they were shifting in their seats. Even one looked to struggle to even stay awake at the end of the day. So it was probably a good call for them to go home for the night and start deliberations tomorrow.
Yeah, the contrast is, and you said the jurors tend to skew a little bit older. I mean, I'm just looking, and I don't know what their ages are. It seems that Mark Richards seems a little bit older than Thomas Binger, not by much, but you know, whatever it is, he's got a little more of my color hair than Thomas Binger does. Anything else happened today? You know, I watched. There were some objections that were, you know, peppered throughout. How was the judge today? Because was there anything that the judge did in front of this jury that was notable? Because we've known that there have been moments throughout this trial.
Oh yeah, there have been. I didn't see or hear the judge yell today. That's that's new for inside this courtroom, Vinny. But there were times. I mean, this judge runs a tight ship. It was a little disjointed early on with the jury instructions because he actually had the jury leave several times. He didn't like exactly how the jury instructions were written, and we also noticed that there was an objection right out of the gate for the prosecution, opening from the defense, and then of course during the defense and rebuttal close as well, there was an extended time where the jury had to leave twice in a row, and that seems to kind of break the flow a little bit. But this is a judge who directly turns and looks at a jury and will speak to them, and you can see the jury responding to Judge Schrader. They will nod to what he says, or if he says, "Do you get it? Do you understand?" They will nod in response to him, and he seems to connect with them because even at the end of the day, after a long day, he's telling them what to expect tomorrow, and they seem to like him, really.
All right, and that, I always say that's the greatest bond inside a courtroom, inevitably, is the judge and the jurors, which is why, as one of the attorneys, you always want to stay on the judge's good side, because if the judge doesn't look like he likes you in front of the jury, then maybe the jurors won't like you as well, because they always trust the judge. All right, Chanley, stand by. Let's bring in our think tank, get some reaction tonight. Joining us in Fort Lauderdale, Florida, criminal defense attorney, civil rights attorney, Kesia Early. In Los Angeles, California, the deputy public defender for Los Angeles County, Philip Dubé. And in Phoenix, Arizona, criminal defense attorney, former prosecutor, host and legal analyst for KTAR Radio. Now that we're in non-daylight savings time, Monica Lindstrom back with us. Great to see everyone. Okay, let me ask you, I'll start with Kesia. Your thoughts, give me the big picture on what we experienced today with these two contrasting styles of approach. You've got one who's like dressed with the pocket square, very deliberate, and the other guy comes out like, what's going on here?
Yeah, you know, Vinny, you picked up on what I was thinking as how the defense attorney is very relaxed and laid back when he's sitting, but the prosecutor is very polished, and you could tell that he picked his suit out the night before. But I would have to say the greatest takeaway for me during closing arguments was the actual demonstration of that AR-15. And then before he even pointed that AR-15, he made sure he let the jurors know that, you know, we want to make sure and check this to make sure there's no live bullets or anything. That was absolutely powerful, because if I'm sitting in that juror seat, just to hear that you took the extra effort to make sure that there was no bullets and that I'm safe. Can you imagine what those demonstrators or rioters, how they were described? Can you imagine what they felt or how they felt when that AR-15 was pointed at them? So I believe that was just very powerful. Kyle Rittenhouse for the defense can't have it both ways. The defense attorney wants the jury to judge him as this childlike 17-year-old. However, I think the prosecution just came back in rebuttal and made sure the jury know that Kyle Rittenhouse created that environment, and he cannot be both the judge, juror, and then ultimately the executioner. So I believe that the prosecution ended strong, and I'm looking forward to the outcome.
Philip Dubé, your thoughts about the closing arguments today?
I thought the defense lawyer was terrific. He had great energy. He was scrappy. He didn't treat it like he was, you know, in the theater in the round. I found Mr. Binger, quite frankly, to be a little unctuous, competitive, and manipulative, frankly. And I think he relied too much on being fitted and styled for the event, you know, literally like it was summer stock, as opposed to trying to prove the case beyond a reasonable doubt. You know, he relied too much on words to prove his case as opposed to the actions of Kyle Rittenhouse. You got to look to his actions because they ultimately speak louder than the words. So, for example, when he told the jury, oh, he claimed to be a medic. We all know that Kyle was trying to be a big shot. But when you think about it, he didn't claim to be part of the Hitler Youth. He didn't claim to be Rambo. He claimed to be the person that was there to help, to protect property, to render aid, not to shoot up the place. And it was only when his life was in imminent danger that he had to use the deadly force.
Monica Lindstrom, what did you see today in these closing arguments?
I saw an extremely sarcastic prosecutor who was very fired up, very passionate, but I could have done without almost all of the sarcasm. When I see a prosecutor, I expect them to be not like a defense attorney, not like it's a play or a movie, right? I just expect them to be a little bit different. And that could be my own fault because that's how I was when I was a prosecutor. His style is impeccable, don't get me wrong, but I don't care about the style. I'm listening to the words. His passion was fantastic. Didn't like the sarcasm. Now, when the defense attorney got up there, I think he was right. He was scrappy. It was kind of like he was reacting to everything that the prosecution threw out there because the prosecution did have a good argument minus the sarcasm. So I thought both did a good job. When they were each done, I was going, oh, yeah, okay, that was excellent. And that's the way you should be after a good argument, at least dealing with the facts, is you're kind of like, okay, well, they brought up a lot of really good points. So hopefully the jury will really look at the facts, right, and the jury instructions, because there's a lot of them, and ignore the sarcasm and the passion that came from both of these attorneys.
Okay, when we come back, we're going to talk about what I believe will be the key issue for this jury, and it's the key for the prosecution if they want to win. It's all about provocation. That's next.